How to divide inherited property between siblings. When people pass away, they often leave behind bank accounts, investment accounts, retirement accounts, real property like homes, rental properties, and other personal assets as inheritance for their loved ones they're leaving behind. But how do two or more siblings divide up inherited real estate and other property? This question has caused countless family quarrels for centuries. However, you can take measures to ensure an equitable distribution of property between your children when you pass, and your surviving heirs can take steps to minimize disputes and allow everyone to benefit from the legacy that was intended for them. Have questions? Schedule a free consultation on our website, rmolawyers.com. How do you split an inheritance fairly? There is no single best answer on what constitutes a fair split of an inheritance. Every family circumstance is different. But let's start with an extremely straightforward and simple example. Imagine mom passes and she's survived by her twin daughters. Neither daughter had borrowed money or otherwise took from mom while she was alive, and the gifts mom did give them during her life had largely been equalized. At her death, mom has $500,000 in the bank and the family home, which we'll also say is worth $500,000. In this case, mom might think that the easiest and fairest estate plan would be to leave one daughter her bank account, either via will, trust, or joint account ownership, and the other daughter sole possession of the family home, again, via those same methodologies. Or mom may think leaving each daughter half of the bank account and half of the house would be best. However, even simple scenarios like this one can cause kerfuffles. In the first scenario, one daughter gets cash while the other daughter gets the family home. If they both have an emotional attachment to the home, the daughter who receives the cash might be upset. And if the other daughter who inherits the home needs to sell it, then she's going to receive less than the other daughter because selling a house comes with significant costs. And in the second scenario, leaving both daughters owning the home together may not work if they don't get along or if they simply can't agree on what should be done with the property. Should they live there? Should one of them live there? Should it be sold, rented? You can see how this can devolve into a dispute. Can heirs property be divided? Heirs property is a term that's sometimes used to refer to real estate and land inherited when someone passes without an estate plan. Because there's no will, trust, or deed to dictate to whom the property should be distributed, heirs property automatically will be divided among and distributed to the deceased's next of kin according to state law after going through probate. For instance, if the deceased was a single man with 3 sons, each of the 3 sons would receive a 1/3 interest in their father's real estate. The laws regarding heirs property vary from state to state. Generally, any of the 3 sons would have the right to live on, work, and through other processes, force the sale of the land. Take a look at our materials on partition actions for more information on selling an inherited property. For the past many centuries, generally land inheritances have consisted of working farms with acreage, which often were left to the oldest child who was taking over the farming operations, or the acreage would just be split between the kids. But what happens today when those same 3 sons inherit a 1/3 share each of the family house on a half-acre of otherwise indivisible land? The first question regarding the heirs' property is who owns title to the house. The short answer is they all do, and if the decedent still had a mortgage, the kids inherit the property with that debt and need to continue paying it or refinance it. They'll need to agree on who's going to pay the mortgage, who's going to pay the property taxes, utilities, etc. Preventing the house from being foreclosed upon is in all of their interests, even if none of them plan to live in it or keep it. And if they can't agree on what to do with the house, then any of them can force a sale, even if the other ones don't want to. How do you buy out a sibling's share of real estate? Buying out a sibling's share of real estate can be challenging. The more people who split a single piece of real estate, the more complicated this task becomes. But having an experienced partition attorney can make the process more manageable. Typically, the easiest solution to these problems is just to sell the family home and divide the proceeds equally amongst everyone. So long as the property's not underwater by debt, selling the house is going to give each heir their share of the inheritance and prevent further squabbles. However, when there are emotional attachments to a family home or other property, often one or more siblings want to buy the other ones out. If we look back at the twin sister example we discussed, If after an independent appraisal, the home's market value is determined to be $500,000, as we discussed, one sister can offer to buy her other sister's half of the house for half that value. Things like who should pay for the appraisal, whether closing costs should be deducted, should there be a minority interest discount applied, etc. All these things can be negotiated. And it's easier if an experienced partition action attorney is involved to facilitate that buyout. Sometimes the sibling who wants to keep the house simply can't get the financing or doesn't have the money to buy the others out. In these cases, an estate litigation attorney sometimes can help guide the parties to alternative financing opportunities and other structures that can facilitate a buyout, including using legally valid promissory notes and other tools. Have questions? At RMO, we protect people like you every day. Give us a call, shoot us an email, or schedule a free consultation on our website, rmolawyers.com. Thanks for watching.